thank you for coming back to our coverage here on the Law and Crime Network. I'm Linda Kenny-Bodden. Now we're switching gears for a moment to discuss the Doomsday cult mom, Lori Vallow Daybell. The Idaho woman, as you know, was convicted in the death of her two youngest children, Tylee Ryan and J.J. Vallow, and her husband's first wife, Tammy Daybell. That was just earlier this month, but now her defense team is calling for a new trial after a juror spoke out. They believe that the juror knew evidence that was not presented in the trial. Jim Archibald and John Thomas also claimed in their motion that the jury instructions were confusing. So why don't we watch some of the juror interview now, and then I'll bring my guests on the other side to discuss the likelihood of a new trial.
Once our verdict was final and we were released from court Friday, as you can imagine, any or most people would have a bunch of questions in their mind. We were not allowed to search the case, look up the case on the internet, social media, watch any videos or news about the case throughout the trial. So, once we were done and we all got to go home and we were released by the judge, on Sunday, my wife and I were watching TV and she said, "Hey, do you want to watch this? There's a new episode." And I said, "Cool, let's watch it." Obviously, I was intrigued. And that's when I learned that in Arizona, there's footage, video camera or video footage from an encounter with Charles, where he is clearly telling the police that his wife has, I believe, deemed him a zombie by the name, I think it was Ned. And to me, again, those were significant red flags about something that's not normal, that should be followed up on a little bit closer. So yeah, that was when I learned about that, and I'm sure a lot more. I can't really remember now, but that's when I watched the videos for the first time on Dateline NBC.
All right, everyone knows my view of this motion, that it's not going anywhere, but that's just one view of one trial attorney, so I want to bring my guests in to discuss this. Now, Matt Mangino, let's get past the fact that there's all this rancor for the defense attorneys making the motion. I said they have to make it, or else, just turn their licenses into the Cracker Jack box they got them out of if they didn't make this motion. But let's put that aside. This motion says the jurors knew information that was not privy, they should not have been privy to during the trial. Did you hear any of that from Mr. Hernandez that would support the motion in that interview?
No, I can understand the basis of the motion. Like you said, they have a responsibility to zealously represent their client. But they're talking about information that was disclosed in a newspaper article that was written and the interview conducted after the trial was completed. So it automatically makes you realize that, hey, there is an opportunity to learn more about different aspects of this case or the defendants after the trial ended, after you were released from any obligation not to look at news reports or other things. And I think his explanation here is quite credible, that, hey, I watched Dateline 2 days after the trial was over, and I learned these things. And when I was being interviewed by the newspaper about them, I thought that these were red flags. Not that I learned that while the trial was going on, or that I learned it outside of the trial while it was being conducted, but I learned it after the trial was completed and I watched a television program. So I don't see a lot of merit to the motion based on what we've seen so far. So I don't know that it's going anywhere.
Yeah, as a matter of fact, if I were a juror and then found out there was this information about Charles afterwards, I'd be concerned about why the police didn't zoom in on anything, although no one really knew about the zombies right beforehand this trial. Casey, let me bring you into this as a defense attorney here. There's also an argument that the jurors were confused, that the jurors used evidence 404B for demonstrative purposes. I don't think that means anything, but there's an argument on the conspiracy. They say that the trial should be overturned because the judge said there could be a conspiracy only between two people. It doesn't have to be all five in the indictment, and narrowed that conspiracy down, and therefore that's not what the defense was fighting against. Do you think that argument is going to go anywhere?
Not at all, because when you're talking about the jury instructions, these aren't instructions that the lawyers just put together prior to closing arguments. These are instructions that have been previously used in other cases. So to make the argument that the jury was confused, although it's the burden of the prosecution to prove beyond a reasonable doubt, it is also the job of the defense attorney to make sure you have your opportunity, not only in opening statements, but in closing arguments, to explain the jury instructions. And if there's any window of confusion, go ahead and explain that. But again, as my colleague stated, this is zealous advocacy. You put any points in that motion to hopefully be granted a new trial so that your client has a second bite at the apple and hopefully will be acquitted the second time around. But as far as the jury instructions being confusing, I do not believe that that's a strong argument to get this motion granted.
Yes, as a matter of fact, Matthew Mancino, I know I'm going to have to let you go before we go to break, but is my view is that, you know, if indeed that there's a conspiracy between two spokes in that bicycle wheel, it doesn't matter whether the other three spokes were involved. It's still the conspiracy that was alleged. But let's go back to the issue of the use of the word demonstrative in 404B. To me, that sounds like the juror was very, very careful, that he knew that the 404B evidence was only for a very certain purpose. And so I thought he was very thoughtful, but others seem to have a different view. Your thoughts?
Well, yeah, I mean, obviously this is a juror that it appears to have taken his job very seriously. You know, he's using terms that are not necessarily always thrown around by people who watch trials or observe trials. And in this case, this is a lay person who's serving as a juror. So, yeah, I think he pretty clearly sets forth in his latest sort of rebuttal to the defense, which is weird. I mean, you don't typically hear jurors come out and kind of make a rebuttal to post-sentence motion or post-trial motions, but that's kind of what we have here. And I think he clearly showed that he was not, you know, using that evidence for any other than, you know, the prior bad act 404 B testimony. So I don't see much merit to that. But we are in a very strange situation where jurors are rebutting defense motions.
Yes, but you know what? The defense basically called him stupid. You know, let's face it. They said he didn't understand things. He sat there and gave his life. And I think jurors in this day and age say, hey, I'm not going to take this anymore. You know, I'm just not. So you have to be careful what you say about a juror. But anyhow, Casey, you're staying with me. Matt Mangino, you have to go back to the practice of law, but I know we're going to see you soon. On the other side, we'll talk about Travis Rudolph. Stay with us.